pre-sentence investigation report, what influence does that have on decisions that you make as you consider that defendant?
Well, that's really a very insightful question, Michael. And one criticism that I have, not so much of offenders, but the defense lawyers, is that so often they just go with the government's offense conduct statement, and they don't spend enough time with their client to contest matters in the offense conduct statement and give the offender's point of view. Because a lot of times when an offender does allocute and explain some things to me, it can differ in nuanced ways from the government's offense conduct statement, and it can often be mitigating. So I think it's really important, critically important, to tell a defendant to go over that pre-sentence report many times, ensure that it's totally accurate, read the offense conduct statement very carefully, and really tell your lawyer how important it is to get your version of the offense conduct statement in the pre-sentence report. And then you better have the facts to back it up if it becomes a contested issue in sentencing, which it can be. Then I listen to the evidence and I decide. And more often than not, when a defendant is willing to contest the offense conduct statement, I find their version of the offense more accurate than the government's version, because the way it's prepared is either the probation officer is looking through the discovery file and draws his or her own conclusions, or the assistant U.S. attorney prepares a one-sided offense conduct statement. So I think it's very important, if an offender can, to challenge anything in the offense conduct statement, to give a different spin on it that might then influence the judge to have a more favorable outlook towards the offender.
Would it behoove him to begin crafting that narrative and writing that narrative even before he has the pre-sentence investigation report, so he can communicate that to the probation officer, thereby giving the judiciary an opportunity to review even before elocution and maybe test the theories that the defendant is offering at the pre-sentence investigation report?
Well, that's one of the best ideas I've ever heard. And the reason why I hadn't thought of it is I'm not sure I've ever seen it. But I would be super impressed in reading a pre-sentence report if I knew that the defendant had thought about that even at the time the pre-sentence report was being prepared, rather than waiting until the night before sentencing to come up with it. So that would be astoundingly impressive to me, to have a defendant that thoughtful and a defense lawyer that thoughtful that they would include that information in the pre-sentence report. And the pre-sentence report, because you read that, it's primacy and recency, because you read that before you go into sentencing. I think most judges read any complicated pre-sentence report at least a couple of times. I know I do. That helps shape your frame of reference and your thinking going into the sentencing. So having something positive like that, as long as it's believable and credible, would really be helpful, have put you in a better frame of mind towards that individual. And if you were skeptical of it, you would have an opportunity then to think about it, what type of questions you might want to ask defense counsel or the defendant, if they were willing to answer the questions, to make sure that the offender is being candid and credible in their comments.